court does call the case of the People's State of Michigan versus Sherrone Moore.
Good afternoon, Your Honor. Katie Rezmierski for the people.
Good afternoon.
Christine Page Jacobs on behalf of Sherrone Moore.
All right, thank you. You may be seated. All right. So date and time set for Frank's here, things have changed. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated.
Thank you, and I appreciate the opportunity to address the court. First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional. Thank you. Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived, based on what we now know, is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts, counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the context of a domestic relationship, and then an additional count of trespass. Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with, pursuant to our obligation of the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor, one comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship. As this court is aware, but I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now, after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove a count of domestic violence in this matter, not historically and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag-on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea as a result of that, but I leave that to counsel.
All right. Did you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the originally charged 3 counts. Thank you.
And that would be an entering of a no contest plea to count 4 and count 5 with the dismissal of count 1, 2, and 3.
All right, very good.
Thank you.
The court does have before it a plea agreement form that indicates that the defendant will be pleading no contest to the charge of malicious use of a telecommunications device with domestic relationship tag. That is a misdemeanor punishable by up to 6 months incarceration. He will also be pleading no contest to the charge of trespass, which is a 30-day misdemeanor. Upon his successful no contest plea to those charges, counts 1, 2, and 3 will be dismissed. That is the court's full understanding of the agreement There is, however, one other thing that should be mentioned, and that is with reference to sentencing. The court is going to be given full authority if the court deems it necessary after a review to sentence under a deferred program. That is the court's understanding.
That is also correct, Your Honor.
That is correct.
All right, very good. Mr. Moore and counsel, if you could approach the podium, please. Okay, gotcha. And if I may have him sworn.
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Sherrone Moore.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about a no contest plea I have to make sure that you understand. First thing is that it first of all means that you're not further desirous or wanting to contest these 2 charges. You understand that, sir?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea, counsel.
The basis for the no contest plea is civil liability,
Potential civil liability. All right, very
yes,
good.
civil litigation.
Got it.
Civil litigation.
Some more to the charge of, let's do it this way. Find the form. To the charge of malicious use of a telecommunications device, how do you plead?
No contest.
To the charge of trespass, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I don't think he has executed any device and rights form, has he? I think he did, actually, but I don't have
I believe he did an
it.
arraignment.
At arraignment, do you recall that, sir?
Not off the top of my head, sir.
Pardon?
Did
Not
you-
off
The
not off
advice
the
and
top
rights
of my
form.
head.
I have one that I printed up just so we can continue. I did go over the advice of rights form with my client yesterday. So him signing it now is acknowledging that he did review it yesterday.
All right, is that correct, sir?
Yes, sir.
All right, I'll let you sign that. Did you have any questions regarding any of the rights that are contained on that form?
No, sir.
All right. You understand that by pleading no contest, you're waiving or giving up the rights that are contained on that form,
Yes, sir.
particularly the rights that are contained under paragraph 5. You'll see a copy on the podium, which are your trial rights. You understand that you're giving up those.
Yes, sir.
All right. You understand you're giving up your right to appeal outright.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed thoroughly Pittsfield Township Department of Public Safety report for their case number 25-25629. Counsel, any objection to the court having reviewed that report?
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these 2 offenses. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit any misconduct as defined under the Michigan court rules, you would first of all not be entitled to withdraw your plea. You understand that?
Yes, sir.
And also, the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any threat, promises, threats, or other inducements which have led to this plea?
There are none, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
Court has.
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. A pre-sentence investigation and report is ordered. Sentencing in this matter will be Will April 13th work for the parties? I have April 13th or April 20th at 11 a.m.
April 13th works for the defense.
Much better, thank you.
Well, hold on 1 second. Hang on a second. April 8th, will that work?
I'm not available. I'll be in trial in Oakland County.
And the sentencing will go smoothly? No. All right. April 22nd in the afternoon.
That's good for the defense.
Will that work for the people?
Judge, I personally will likely be unavailable in a trial, but it sounds like my office could make certain that it's covered.
Well, we've been here from the beginning. We might as well try to make it work for you too. Give me a special day.
Tuesday, April 14th
Will the
in the afternoon.
April 14th in the afternoon work?
That should work.
I'm checking. April 14th works for the defense.
April 14th, 2026 at
2 p.m.
2 p.m. Before me. Anything else to bond?
Nothing from the people. Oh,
Yes, as to bond, we are asking that the bond condition of a GPS tether be removed as a condition of bond for the following reasons. The tether was placed when it was the understanding that the charges my client was facing was a felony and a stalking charge. Now that those charges are dismissed and the narrative of my client being having a history of violence and stalking has now been proven to be false, it's our position that the tether is no longer necessary. There is still in effect a no contact order by my client to the complainant or by any third party to the complainant. He will absolutely abide by that no contact provision, and he has no intent to, by himself or anybody else, to contact the complainant.
All right. Any response from the people?
Your Honor, I would say that I am comfortable leaving the matter of the tether in the sound discretion of the court. I will reiterate that our victim's most fervent desire is that the no contact, either direct or through third party order, remain in effect, and that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or a third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as the defendant has been interviewed by probation, and then I will make a decision on that based upon a recommendation from probation. All right.
Thank you for that consideration.
Thank you. Anything additional?
No, Your Honor.
Nothing from the people. Thank you.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
Thank you so much.
Court stands adjourned.
All right. Court is adjourned.
Thank you.
You